I rise in opposition to this judicial reappointment. It's not something I relish doing. When we vote on policy, we're voting on words on paper, whether or not certain laws or statutes should affect the lives of our constituents. When we do appointments, executive nominations, and particularly judicial appointments, and certainly judicial appointments at this level, we're actually voting on a person, and it makes it a little bit more difficult. But I feel compelled today to rise and express my objections to this particular nominee. And as we go, I think you'll understand that my concern is not limited to this nominee. It is basically the entire Supreme Court of the United States of the state of Connecticut, rather, as it has operated, I'd say at least over the last decade or so. I've served on the Judiciary Committee for a number of years. I had the opportunity to interview a number of judicial appointments along the way. I've always been a little bit frustrated by that process and the fact that we often move certain nominees forward without the proper review, and maybe sometimes with too much regard for continuing business as usual, instead of reminding ourselves of our responsibilities and our duties as a legislature. There's 3 branches of government, and each one of them is required to be a check on the other. And if I had to nail down one concern I have about our Supreme Court in Connecticut and this judge in particular, I would say that they have failed to be a check against the executive branch on many occasions, and failed to be a check on this legislature every so often as well. I've always, when faced with any type of judicial appointment, asked myself the same question, which is, does this judge apply the law as written, or are they, in viewing their experience, in viewing their decisions, are they acting in some other interest, maybe to reshape the outcome, to inject a political motivation? I don't want to speak to anyone's motive today, particularly Judge Ecker. I have seen his photo, but I can tell you I couldn't even pick the man out of a crowd. This is not a personal issue for me. This is all about judicial philosophy and constitutional fidelity. But I am concerned that in a number of cases, which I'm going to just go through a few examples, he has aligned his decisions with other members of the court to expand executive authority, to stretch constitutional meaning, and to undermine what I think are some structural elements in our system that threaten the liberty that we all cherish. And as I said, this is not aimed directly at Judge Ecker, although I'm going to apply my comments today to him and his personal record because he's the one up for nomination. But I'm speaking to the whole court when I express my concern over some of these decisions. I think that one of the reasons why I wanted to speak today is not so much because I have a concern about this particular nominee. I'm confident that this nominee is going to pass this chamber and probably without much opposition. But I wanted to get up and just remind my colleagues that our job is to keep that check in place. And if we're not constantly reviewing how our judicial appointments are behaving on the court, I think we're failing in that regard. And I see a situation like this, where periodically we get the opportunity to reappoint judges to the various courts in our state as the chance we have to really take an in-depth look at what the behavior has been and whether or not we need to make changes. In my view, this is an opportunity to correct the direction our court has been headed in. So let me just talk about a few of these cases. And I'm going to tell you that some of these are very personal to me. And the first one is the Casey v. Lamont case from 2021. This is a case all about the actions of the governor of our state during the pandemic. And And I recall coming into this chamber numerous times over the course of about a year and a half and having votes extending the governor's emergency declaration that we were in a public health emergency, to advance or at least rubber stamp his executive decisions, and to continue to give him the power to make executive orders and effectively run this state as a one-man policy-making machine. And the thing is that that's not how our system is supposed to work. The executive authority that's granted in our state constitution limits the governor's ability to simply modifying existing statute in the case of an emergency if he has to accommodate a certain circumstance. And from my view, that would be minor changes to existing laws. This governor decided that he was going to create policy out of whole cloth in a number of examples. So the number one example, I think, would be the determination that some businesses and some individuals are considered essential, and while others are considered non-essential. And he made a determination that certain businesses in the state could remain open while others had to be closed. And I remember coming into this chamber and complaining that it made no sense that we had a situation where we had a mom and pop store, a dress shop or something like that, where they might have one or two customers a day and they're not even really interacting with another, and they were forced to be closed under the governor's executive orders and his determination about what's essential and what's not. Well, meanwhile, Walmart, Target, liquor stores were allowed to remain open. They were telling churches to be closed while liquor stores were remaining open. And there was no actual law that you could lean on that would have allowed this. It was the governor acting on his own as judge and jury, because he was able to determine, based on his own opinion, what a public health emergency is. And I remember asking in this chamber, what's the emergency? What's the emergency? And the answer is, Ned Lamont thinks it's an emergency. Much like our emergency certified bills that we see come to this chamber are an emergency simply because the powers that be say there's an emergency, whether there actually is one or not. So the governor was challenged in court on exceeding his executive authority. That's what this Casey v. Lamont case is. And the question was very simple. Does the law allow that level of ongoing executive power? And the court said yes. And I find that deeply troubling, because one of the reasons why I was standing in this chamber so many times, every time we extended those emergency powers, was not because I thought I was going to be able to convince my colleagues on the other side of the aisle that somehow I'm right and that we ought to check the governor. I was reminding the courts. I was bringing up exactly what their obligation is to the people of Connecticut. But just like the majority in this building ignored me, so did the Supreme Court of the state. The decision turned a temporary emergency tool into a standing grant of legislative power to the executive branch. And it was wrong. And they got that decision wrong. And Judge Ecker was part of that decision. Also in 2021, there was another pandemic-related court case. This is the Fay v. Merrill case. Merrill being the Secretary of the State, Fay being Mary Fay, who brought a suit to the state of Connecticut regarding absentee ballot voting, because the plaintiff in this particular case was concerned that our state constitution limited absentee voting to very specific circumstances. For people in the military, you're out of town, the standard reasons for absentee voting that we've had for decades. And one of those reasons was sickness. And it was always understood to mean that sickness meant your sickness, because you were sick and you couldn't go to the polls, therefore you could vote by absentee. The pandemic changed all that. I think the governor, I think the Secretary of State, I think the majority wanted to make sure that there was a mechanism to make sure that people voted. And I do not deny the desire of me and other people in my party to try and create a mechanism so that we didn't have a election with 1% turnout because of the pandemic. But at the same time, we still have to live within the constitutional framework that existed. You can't just ignore the Constitution because it was convenient to at the time because of extenuating circumstances. But that's exactly what happened. In that case, the court was asked to define what sickness means because the idea had been floated that because COVID existed, that gave people a carte blanche reason to vote by absentee. So the court was asked to really define what sickness is. And they went overboard, in my view, and basically came up with the conclusion that sickness itself as a word was the reason, not your sickness or a family member's sickness or the fear of a sickness, simply the word sickness. Maybe because sickness has existed in the past, will exist in the future, maybe around the corner. And in my view, that was a complete and utter stretch of the constitutional meaning. And what's interesting and evident is that the majority party came back into this legislative body following that decision to actually pass a law to rewrite the statute to redefine sickness in the framework of the court's decision. That is the exact opposite of how we're supposed to do things. If the legislature wants to redefine the word sickness and they feel that they can do it within the confines of the constitutional framework, then we can. And then the court should uphold that decision. But we should not have courts making policy, especially long-standing policy about something as important as our election process. And that's exactly what happened. So in this particular case, the court replaced clear text, a clear definition, with a policy-driven interpretation that suited them at the time because of the circumstances on the ground. And the danger here is if the word sickness can be redefined into anything the government wants it to mean, then the Constitution no longer sets any limits. It becomes flexible to political convenience, something that I raise awareness about in this chamber all the time. Words have meaning. We have to do a better job of writing the laws that we do, because I see bills coming through committee that are filled with very, very unclear terminology. Substantial. What's substantial? These are the kind of things that ultimately end up in courtrooms and frankly make attorneys wealthy arguing over whether or not the limits have been met for all of these vague terms. We should do a better job determining what the parameters of the legislation that we pass are. I'm going to mention one other case with a little bit of detail, and then I'm just going to reference a few other ones. But this one is Connecticut Freedom Alliance versus the Department of Education, 2023. And this is in the wake of the pandemic also, where people were being required by our government without any real definitive explanation or statute to rely on, but they were being told that they were required to wear masks in locations throughout our state, forcing retail stores to require their consumers and customers to wear masks without any statute to rely on. It's now a mandate from the state of Connecticut. No law associated with it, nothing. This is a medical mandate that everyone must follow. This got so bad that people were being told that they could not participate in their local government meetings, that people were not allowed into a Board of Education meeting because they refused to wear a mask to do so. And of course, some people were actually arrested in these circumstances. Of course, they could not be tried or charged with anything because there's no crime, because there's no actual statute. It's a mess. But this entire state was caught up in it, and everybody was following a law that wasn't a law. But the Connecticut Freedom Alliance actually challenged these medical mandates, this mask mandate, because they felt, as I do, that this is not how we're supposed to operate. Our state government is responsible back to the people that we represent. We have got to write our laws in a clear fashion, and they've got to actually become law through a process. Ideally, we follow the full legislative process, including hearings, committee debate, and so on. But in this particular case, some might say this is not such a terrible decision because of the facts are simply that the court dismissed the case out of hand, simply stating that, well, the pandemic's over and the mask mandates are over, so we don't need to hear the case. But that's not good enough for me, because if the government can avoid judicial review simply by timing its actions or delaying a decision in court over a very important factual determination for the people of Connecticut, then there are no constitutional limits. Again, things like that become unenforceable. There's a few other cases that I'm just going to briefly describe them. There is CHRO versus Edge Fitness in 2022. This was a case where the court had to decide what was more important. In Edge Fitness is a gym, and basically they set up part of the gym or some of their health classes, or they set up a section for women versus men, and a transgender biological male complained under our gender identity or expression constitutional protections that we have in the state of Connecticut. And that's a legitimate claim. I voted against it. I thought it was crazy. I still do. I think people are biologically what they are, and just because you want to claim that you're something that you're not doesn't change reality. But the fact of the matter is we have that. I respect the law, even if I don't like it, because I know that it went through the process and we determined that that's what the case is. But that was not the only consideration in this case. That was just half of it. The other argument was about the right to privacy that the lady consumers of this gym were entitled to. So the court had to make a decision. In my view, they made a political decision. And they made a political decision in favor of non-science and a lack of reason. They elevated one interest, which I think in a more legitimate case about discrimination, I might see it their way. But in this case, they elevated the discrimination issue above the privacy issue, and they did so without any clear legislative direction. Nothing that you could point to say that one was more important than the other. In 2021, there was a case regarding a gentleman that received a parking ticket, and he went off on the cop that gave him the ticket. And I'm not defending that person's actions, but ultimately that person was prosecuted under a statute that we refer to as the fighting words law, which is a significant crime, and being charged with it and being convicted of it carries a stiff sentence. This is a lot different than the freedom of speech that I think was being exercised in this case. So I think that was a situation where the court expanded exceptions that give the government more power to decide that they're going to prosecute someone on the subject of speech. Anyone who loves this country and knows our history understands the value of the First Amendment, and that the reason why the First Amendment exists is not to protect popular speech, it's to protect unpopular speech. And some guy going off and maybe swearing at a police officer who gave him a ticket might be guilty of something, but he wasn't guilty of fighting words. And I'm concerned that the court didn't consider the value of protecting the freedom of speech in that particular case, even though I certainly condemn the behavior of the gentleman who was, probably not so kind in that case. There's another case, the Murphy v. Rosen case, where our state Supreme Court upheld that calling someone a white supremacist on social media was protected opinion. I want to give a shout out to my GAE colleague, Representative Blumenthal, because we had a great conversation in committee the other day about his bill regarding deceptive synthetic media, which is all about deep fakes and what is protected political speech, and more importantly, what is defamation, what is slander. And he very clearly explained to me something that I understood, but not as clearly as he described it to me, which is that there's a difference. If you say Senator Sampson's crazy, that's an opinion. But if you say Senator Sampson was institutionalized for a mental illness, you're making a statement of fact, and that is actionable as slander or defamation. So you have to be careful, particularly when you're engaging in speech condemning another individual, that you do not cross the line into making a statement of fact that could be damaging to their reputation and character, because you can be sued for defamation or for slander for doing that. I cannot think of something worse than to claim someone else as a statement of fact that they are a white supremacist. And this court said that that was merely opinion. The danger here is that by protecting the ability for individuals to call each other white supremacists without any fear of defamation, which is now precedent in our state, you're essentially creating a situation where you're going to make it much more difficult to hold people liable when they do defame one another. There was a case, State v. Enrique H., which was just a case about someone who had a protective order against them, but they were also attempting to protect their own constitutional right to own firearms. And the court basically negated that person's ability to be able to make the case for why the protective order was invalid, which denied them a constitutional right. And this one's a little bit more complicated, but the fact is, before the state of Connecticut, in its decisions as an executive branch, decides to violate someone's rights, a constitutional right for some other lesser crime, they ought to be held to a standard. And I believe the court should have said, you can't take someone's constitutional right away for such limited purposes. You should have given that person an opportunity to make their case about why the underlying charge was not relevant. There's a couple more, but I guess you get the gist. No single case is going to determine whether I think a judge is an activist judge or they're denying their obligation to uphold the Constitution. But I do think that patterns matter. And across multiple cases, Judge Ecker has aligned his decisions with expanding government authority, stretching constitutional meaning, and weakening those structural safeguards I mentioned at the outset. That's not a technical disagreement about any of these cases. That is a philosophical direction, and it's being done on purpose. And as I mentioned, it's not just him. I think that this is the direction of our state Supreme Court generally. And I think that's a reason for us to pause today and consider whether we ought to correct the direction of our courts. Our courts are supposed to be the check against us as a legislature. They are supposed to be a check against the executive branch. When one party holds power for a very long time, a lot of things happen. Democrats control majorities in both of these chambers. They control the governor's office, the executive branch, all of the institutional mechanisms of government, every state agency. And also because they're in power, they appoint the majority of judges and justices. But there have got to remain clear, definitive separations between these branches of government. The concept of separation of powers is so important that I'm encouraging my colleagues to think hard about this, that we have an obligation to check people that we might even philosophically agree with if they are going beyond where they are supposed to in the role that they serve. And I believe our Connecticut Supreme Court has taken many opportunities to choose a philosophical direction that is in direct contrast with our system of laws and justice, our Constitution, federally and in the state. And it should stop. And people in both parties should say, even though I like the outcome, the court didn't have the right to do that. The court should not have allowed the governor to continue on that path. It's so ironic with the rallies we've been seeing about no kings. But effectively, a number of these decisions have empowered the executive branch to act in a very authoritarian way, to make policy out of whole cloth without legislative approval, to continue extending public health emergencies when no emergency was in sight, when there were fewer than 5 people in the entire state in the hospital for COVID, we were extending the public health emergency because the governor said so. There has got to be a limit to your desire for political partisanship and advancing your agenda when it's being done through means that are not appropriate. This is the body that makes the political decisions, that chooses our policy because of our political agendas. But we are held in check by the framework of our Constitution, and we are held to that framework by the judicial branch. And if the judicial branch is not doing that, that's a problem. That's all I have today, Madam President. Thank you.
Thank you, Senator Sampson. Will you remark further, Senator Looney? Have all the senators voted? The machine will be closed. Mr. Clerk, kindly announce the tally.
Total number voting 32. Those voting yea 24. Those voting nay 8. Those absent 4.
Resolution is adopted.